good afternoon, and welcome back to Thorough Newspaper Analysis. So today is 6th of September, and this entire video series, it's brought to you by LawSikho. So let's quickly head to the agenda for today. Now, the first segment for today's discussion would be the editorial segment, and here we've taken up an Indian Express article, which is titled as this: Citizenship, Corruption, Reservation, Three Major Cases Before the CJI-led Supreme Court Bench. Here, essentially, we're going to deal with the recent development whereby the Supreme Court has constituted a constitution bench, which is led by the Chief Justice and has four other judges. The purpose of this constitution would be to hear three important cases. We're also going to understand a key concept which is called Assam Accord. Secondly, we talk about the news updates of the day. And thirdly, we have a look at the legal news of the day. So without further ado, let's start with the article discussion and let's see the context of this development. The Supreme Court, it has constituted a new 5-judge constitution bench to hear three important cases. What are these cases? So the first of the cases, Assam Public Works versus Union of India and others. Secondly, we have Ashok Kumar Jain versus Union of India and others. And the third case being Sita Soren versus Union of India. We're going to take up all of these cases for discussion one by one, but for now, these are the names of the cases. The bench, it will be headed by the Chief Justice of India, Honorable Justice Dr. D.Y. Chandrachud, and this bench is going to have the following judges. We have Honorable Justice A.S. Bonappa, Justice M.M. Sundaresh, Justice J.B. Pardiwala, and lastly, Justice Manoj Mishra. The cases before this bench, they range from a challenge to the constitutional validity of a section in the Citizenship Act of 1955, and this section is Section 6A. This is the subject matter of the first case. Secondly, there is a challenge to the extension of the reservation in the Lok Sabha and the state legislatures, which is given to the scheduled caste and the scheduled tribe members, which was initially given for the period of 10 years after the commencement of the constitution, but by virtue of subsequent amendments has been extended. So one such amendment extending this tenure is under challenge in this case. The third case, the subject matter of which is this: the question of legal immunity, which is enjoyed by the MPs and the MLAs from being prosecuted for offences such as offering or accepting bribes for casting votes, that will also be decided. So let's take up the first case for discussion first. The title of this case is Assam Public Works versus Union of India and others. Before we get into the technicalities of this case, let's understand something called as Assam Accord. I'm sure you would have heard of this term a lot while the entire debate around the Citizenship Amendment Act was going on. So see, northeastern states have always had this one problem of influx of illegal immigrants from now called Bangladesh. And it has been their constant complaint, and especially this complaint was there in the 1970s, 1980s, that owing to this influx of illegal immigrants, our state, we are losing our state identity, and there is scarcity of resources, there's scarcity of jobs, and we're facing problems. Now, during the time period of 1979 to 1985, there was agitation. There were multiple repeated agitation for a period of 6 long years by student unions in the state of Assam. And again, their very grievance or core of those protests was the influx of illegal immigrants from Bangladesh. And it was the demand of the student union that you detect these illegal immigrants and that you deport these illegal immigrants. Now, as a result of this Assam Andolan, which carried on for 6 long years, the Rajiv Gandhi government, which was at the center back then, it had to sign a memorandum of understanding with those student union leaders. And this memorandum of understanding, it was signed on 15th of August in 1985. And that is what we call the Assam Accord. Now, there are 4 or 5 prominent clauses of this accord, but for the purpose of our discussion, I am going to take up 3 such clauses. First, we need to understand that the Assam Accord, it provides that all of those immigrants who have entered Assam before this particular date, which is 1st of January 1966, or to say 31st of December 1965, up to that date, they will automatically be considered as the citizen of the state of Assam, as the citizen, they will be given the citizenship, and also they will be given the right to vote. So automatic citizenship for those who've entered the state of Assam before this particular date. Now, those who've entered between this bracket, which is 1st of January 1966 to 24th of March or 25th of March 1971, all of those, they will be detected and they will have to come out and say that, I'm a foreigner, or they will have to be detected. Their names from the electoral roll, they will be deleted, and they have to make themselves registered under an act which is called the Registration of Foreigners Act of 1939. And after they've registered, also their right to vote will be cancelled for a period of 10 years. So suppose somebody got himself or herself registered today. So from today to 10 long years, their right to vote will be taken away. They will be disenfranchised. Their names from the electoral roll will be taken away. However, after the lapse of 10 years, their right to vote will be reinstated. Now comes those people or illegal immigrants who have entered Assam post this date. So for these, the Accord proposes 3D solution or formula. What is 3D solution? The Accord says that we detect these people, we delete their name from the electoral rolls, and we deport these people because they are illegal, they're foreigners, they're illegal immigrants. So that is the crux of the Assam Accord. Now let's get to this case. The question under scrutiny here is whether Section 6A of the Citizenship Act of 1955, it suffers from any constitutional infirmity. What does this section provide? It provides for special procedure or provision as to citizenship of persons who were covered or are covered by the Assam Accord. The section says that all those who came to Assam on or after this time period, which is 1st of January 1966, but before March 25th, 1971, they will be, and they have come from this time bracket from specified territory. What is this specified territory? It is the territory included in the territories of Assam at the time of commencement of the Citizenship Amendment Act of 1985. And ever since they are residents of Assam, they must register themselves under the specified rules for citizenship. Now, the plea which is challenging the constitutionality of this provision, it was filed by a Guwahati-based civil society group which is called the Assam Sammilata Mahasangh in 2012. The major contention of these petitioners was that this particular section, it is discriminatory, it is arbitrary, and it is illegal. Therefore, it violates Article 14 of the Constitution. And what is the ground on which they are contending that it is discriminatory? The ground is that it is providing different cutoff dates for regularizing illegal migrants who are entering Assam and other parts of the country. Now moving on to the next case for today, which is Ashok Kumar Jain versus Union of India and others. In this particular case, the bench will deal with a challenge to the validity of Constitution's 79th Amendment Act of 1999. By virtue of this amendment, reservations which were given to the scheduled caste, scheduled tribes member, and the Anglo-Indians in the Lok Sabha and the state legislative assemblies, it was extended beyond the earlier period of 10 years as provided in Article 434 of the Indian Constitution. See, here we need to understand that Article 334 of the Indian Constitution, its marginal note, it provides reservation of seats and special representation to cease after certain period. Originally, at the time of commencement of this constitution, this article simply provided that there is going to be reservation of seats for the members of the scheduled castes and scheduled tribes in the Lok Sabha and in the state legislative assemblies. Similarly, there is going to be a reservation for Anglo-Indian community in the Lok Sabha and the state legislative assemblies for a period of 10 years. However, subsequently, by virtue of a lot of amendments, if you have the Universal Bare Act with you, and if you refer to the footnote of the section of this particular article, you would see a lot of amendments. So, let's say there is the 23rd Amendment. By virtue of all of these amendments, this period of 10 years, it was further extended. So, let's say the period of initial 10 years, it was extended to 20 years, and then other 20 to 30, it became then 40, then it became 70 years, then it became 80 years by virtue of a lot of amendments. One such amendment is the 79th Amendment, and there's also 95th Amendment as well. So Article 334, it deals with the reservation of seats and special representation in the Lok Sabha and the state legislative assemblies. Although it was initially meant to continue for a period of 10 years, subsequent amendment, however, like the 95th Amendment Act of 2009, it extended the reservation to these groups for 70 years for Anglo-Indians community, and for members of the scheduled caste and scheduled tribes, this period was extended to 80 years. However, in the year 2020, on January 21st, by way of Constitution 104th Amendment Act of 2019, reservations were extended to scheduled castes and scheduled tribes for 80 years again, but the reservation, which was earlier granted or extended later to the Anglo-Indian group, it was discontinued. So last year, on 24th of August, the top court, it listed the matter for consideration by a 5-judge bench led by CJI DY Chandrachud, and the case, it can be expected to be finally taken up now. The third case for today would be Sita Soren versus Union of India. Here, the question for discussion is whether Article 194, Clause 2 of the Constitution, whether this article, it confers any immunity on the members of the Legislative Assembly from being prosecuted in a criminal court for an offence which involves the offering or the acceptance of a bribe. This particular article, it states, no member of the legislature of a state shall be liable to any proceeding in any court in respect of anything which is said or any vote which is given by him in the legislature or in any committee thereof, and no person shall be liable in respect of the publication by or under the authority of a house of such a legislature of any report, any paper, votes, or proceedings. So, this is the background of this case. This case arose out of a plea which was filed by Sita Soren. She was a member of the Jharkhand Mukti Morcha, and she was accused that you were accepting a bribe to cast vote for a certain candidate in the 2012 Rajya Sabha election. As a result, the CBI, it filed charge sheet against her for allegedly accepting a bribe to cast her vote in the Rajya Sabha election. However, it was her case that she was protected by the immunity which is granted to her by virtue of Article 194(2). But her plea, it was rejected by the Jharkhand High Court in 2014, and as a result, she approached the Honorable Apex Court. Now, in 2019, a 3-judge bench of the Supreme Court, it cited a Constitution bench ruling only, which was the case of P.V. Narasimha Rao versus State. In this case, the Apex Court had ruled that under the Constitution, parliamentarians, they were entitled to immunity against criminal prosecution concerning their speech and their votes in the House. So following this, the bench, this 3-judge bench, it referred this matter to a larger bench of 5 judges. And now the Constitution bench, newly constituted 5-judge bench, it is going to have a look at this case. So with this, let's proceed to the National News Center for today. And the first update is this. Private banking company, which is HDFC First Bank, it has recently announced that it has integrated central bank digital currency app with UPI QR codes. If you remember, a couple of days back, we did a similar story update on SBI Bank. So SBI, it has also integrated the CBDC app with UPI QR codes, and similar update has come from HDFC First Bank. This new feature, it simplifies the process for merchants to accept payments which are made with the digital rupee. This development, it allows the individuals to easily use digital rupees for payments through existing UPI QR codes which are placed at various merchant outlets. Let's understand the concept of central bank digital currency or e-currency, digital currency, e-rupee again. So CBDC or the central bank digital currency, it is a legal tender which is issued by the RBI. If you have a look at the physical currency that we have, let's say a 10 rupee note or a 100 rupee note, you can see there is a declaration which is made on the note itself that, I so and so, the Reserve Bank of India has given me this currency note. So basically, what does this do is, by virtue of such a declaration which is issued by the RBI, there is faith, because what is a note? A note is just a mere, piece of paper. So why there is this value which is attached to this note? This is because of the faith which is given by the Reserve Bank of India. So similarly, this is called a digital rupee or e-rupee. It will offer features of physical cash like there's trust, there's safety, there's settlement of finality with this digital currency. E-rupee, it represents a direct claim on the central bank, and it can be used to carry out transactions or store value digitally, similar to the manner in which currency notes they can be used in physical form. So it was introduced by the RBI last year. It represents a digital form of the legal tender which is issued by the central bank. It possesses essential qualities like physical currency, including the trustworthiness, the security, and the capability for instant settlement in digital realm. SBI Securities, it has appointed Suresh Shukla as the Chief Business Officer. SBI Cap Securities Limited, which is the broking arm of the State Bank of India, it has announced the appointment of Suresh Shukla as the Chief Business Officer. In his new role, Mr. Shukla, he will be at the helm of driving the company's business operation, and he is going to play a very strategic role in spearheading the next level of growth. Prior to joining the SBI Cap Securities Limited, Mr. Shukla, he had held key leadership positions at Kotak Securities Limited. Lokesh Suji is elected to International Esports Federation Membership Committee for 3-year tenure. So there is a federation at the global level for the purpose of esports, and that federation is called the International Esports Federation. The general body of this federation, it has elected Mr. Lokesh Suji as who is the director of Esports Federation of India and also the vice president of the Asian Esports Federation to its esteemed membership committee, and this selection is for a tenure of 3 years. This election, it marks the first time that an Indian has become a part of the membership committee of the International Esports Federation. This federation, it is a global esports organization which is working towards promoting esports as a true sport beyond any sort of barrier, be it due to language, race, or culture. Mr. Lokesh, he is a pioneer and well-known respected figure when it comes to the Indian and global esports industry. As far as his role in the Indian esports industry is concerned, under his guidance, our esports federation, it has established a thriving ecosystem for esports in our country, contributing significantly to the official recognition of esports here in our country as a multi-sports event by the Indian government. The Indian Federation, it has been sending the Indian esports contingent to major multi-sports tournaments such as the Asian Games 2018. In these games, esports was demonstrated event, and the Commonwealth Esports Championships last year, that is another event where we sent our contingent, and here the nation's talented athletes, they scripted history by securing the historic bronze medal at games like Hearthstone, and we have Dota 2. These are esports or online games. Next up, we have this update. So this is an interesting update for pet lovers. North India, it has become first dog park. It has become or it has gotten its first dog park in Ludhiana. After a patient wait of about 2 years, Ludhiana, it has unveiled North India's first dog park. This is situated in Block D of by Ranveer Singh Nagar, and it was inaugurated by the area MLA, who is Gurpreet Bassi Gogi, and MC Commissioner Sandeep Rishi. Ludhiana has now become the first place in North India to have such sort of a facility, and it has joined league of cities like Mumbai and Hyderabad, which host the country's two other such facility. As far as the amenities in this particular park are concerned, it includes training equipments like hurdles. There are tunnels as well as designated obedience training zones as well. These are developed to foster canine development, ensuring both mental and physical simulation. In addition to this unveiling, plans are in motion to introduce a pet cafe, pet boarding, pet grooming, and other facilities in the near future. The timings of the park is 6 a.m. in the morning to 11 p.m. in the night, and the nominal fee of rupees 40 is going to be charged. Assam government, it forms a three-member panel to draft anti-polygamy law. The Assam government, it has constituted a three-member panel to draft the proposed law to end polygamy in the state. The members of this committee, they are Advocate General Devjit Sekia, we have Legal Remembrancer Kuntal Sharma Pathak, and Director General of Police Gyanendra Pratap Singh. Assam government, it had earlier formed a committee. This committee was headed by a former Guwahati High Court judge, Justice Rumi Fukan retired. The purpose of this committee was to examine the legislative competence of the state legislature to enact an anti-polygamy law. The state government, it had sought public views on the proposed anti-polygamy law, and of the 149 individuals and organizations that responded to this call by the government, 146 they supported the move and 3 of them they opposed. This committee, which was constituted by the government and headed by the former justice, this committee had scrutinized the provisions of the Muslim Personal Law Shariat Act of 1937 along with Article 25 of the Indian Constitution in relation to the directive principle of state policy for uniform civil code. I have two questions here, and I would request all of you to please put down your answers in the comment section and let's be more participative. So first question is, which article of the Indian Constitution it provides for the uniform civil code? And secondly, this case law, we also covered it in one of our TNS as well. So by virtue of which case the Supreme Court has categorically held that even if, let's say, a husband converts to the Muslim religion without divorcing his first wife and marrying for the second time post conversion, so such sort of a husband will also be liable for bigamy, and he cannot take this deviated route to save himself from the penal consequences which are provided for bigamy in IPC. And the third question is, which section of the IPC provides for the penal sanctions or the penalty for bigamy? Please put down your answers and let us know in the comment section. This is another update with respect to the e-sport venture. So Ranveer Singh, Bollywood actor, he joins BGMI as brand ambassador. Krafton India, which is the company behind BGMI, it has announced a collaboration in India. Bollywood actor Ranveer Singh, he has been named as the official brand ambassador for this game, which is called Battlegrounds Mobile India. We can say this is a revamped version of the PUBG game. So as part of the campaign, BGMI players, they will be urged to hold and celebrate their authenticity in battlegrounds. Next up, we have an update in the segment of defense for today, and this is also a very important update. Naval Commanders Conference, Maritime Infrastructure Perspective Plan for 2023 to 2037 it is released. During the Naval Commanders Conference, the Minister of State for Defense, who is Ajay Bhatt, he released the Maritime Infrastructure Perspective Plan for 2023 to 2037. This plan, it aims to create sustainable architecture which is aligned with and it is in sync with the border policy directive of Pradhan Mantri or PM Ghati Shakti project. Before we dive into this update, let's have a look at this scheme first. So on 13th of October in the year 2021, our Prime Minister, he launched the Pradhan Mantri Ghati Shakti scheme, which is a rupees 100 lakh crore project for developing holistic infrastructure, which is aimed at revolutionizing the infrastructure sector in India. Basically, the purpose simply explained of the scheme would be that there are a couple of ministries. Let's say we have the railway ministry, we have ministry which is responsible for roads and highways, petroleum, all of these ministries, the aviation department as well. These ministries and departments, they have their infrastructure projects going on. And because of the bifurcation of these departments and industries and ministries, there is a lot of delay because of seeking clearances and other formalities. So, by virtue of this scheme, one of the core functions of the scheme would be that we streamline and sync and coordinate and connect all of these infrastructure projects within these ministries and government bodies so that we're able to develop good infrastructure. So, how does it work? See, to get the mission going, there is going to be a centralized portal which will be set up to unite the infrastructural initiatives planned and initiated by 16 central ministries and departments, including the railways, the roadways and the highways, the petroleum and gas, power, telecom, shipping, aviation. By putting in place better coordination among these ministries, this portal, which also aims at centralized transportation and logistics grid, it will enable smoother information flow, and this is going to fast track project clearance process as well. So what are its key objectives? With the broad objective of making products which are manufactured in our country more competitive. How do we do that? If we cut down the logistics cost and if we improve the supply chain, then the products which are manufactured in our country, they're going to become more competitive. So by doing so, this scheme, it will help India attract investment from all over the world for improving the infrastructure in the country. Logistics and supply chain. So this is a fact that we can take note of for the purpose of better understanding. Logistics and supply chain costs, they account for nearly 12% of GDP in India. If we see the global average, it is merely 8%. So now let's come back to this scheme, this particular update. So what happened was that during the Naval Commanders Conference, this plan, which is Maritime Infrastructure Perspective Plan, it was released by the Minister of State for Defense. This was the second edition of this exercise. It began on September 4th in New Delhi. The conference, it is the apex level biannual event, facilitating interaction between the naval commanders for deliberation and formulation of important policy decisions. During this 3-day conference, the Chief of Defense Staff General, who is Anil Chauhan, this is also a question that may feature in your exams. So the Chief of Defense Staff General Anil Chauhan and senior naval leadership, they were present. They reviewed the status of the decisions which have been taken during the first edition of the conference outside Delhi in 2023. The first edition, it was conducted on board INS Vikrant in March of 2023, and the second edition, it started on 5th of September. Moving on to the next update. This has brought us to the international segment for today. Indian American Arjun Gupta, he is appointed chair of the US federal body. Indian American executive Arjun Gupta, he has been appointed as the chairperson of the newly established Federal Investment Capital Advisory Committee. This committee will advise the United States Small Business Administration in development of a more inclusive and accessible ecosystem for small business nationwide. About Mr. Gupta, he's the founder of Telesoft Partners, which is a venture capital firm founded in 1996. Over the last 25 years, he has invested in more than 250 private technology companies, resulting in over 150 acquisitions and IPOs. He has raised a cumulative capital investments of around $1 billion. As far as his educational background is concerned, he has earned his MBA from Stanford University, an MS and BS in computer science from Washington State University, and BA honors in economics from St. Stephen's College in India. He is an advanced leadership fellow from Harvard University and also a Henrytown Fellow and trustee of the Aspen Institution. He is also the co-founder and the former co-chair of YPO Aspen. Moving on to the last update in the international segment for today. Former Mossad chief, who is Shabtai Shavit, who helped forge peace treaty with Jordan, he dies at the age of 84. Shabtai Shavit, who was at one point in time, in fact, at a very crucial point in time, director of Mossad, which is the intelligence agency of Israel, he has passed away at the age of 84 in Italy. He played a very monumental role in arriving at Israel's historic peace treaty with Jordan. He led the Mossad, which is the intelligence agency of Israel, from 1989 to 1996, guiding the agency through a very, very critical juncture in the Middle East history. During his time, he oversaw Israeli operations on foreign soil during the collapse of the Soviet Union, the end of the Cold War, and the first Gulf War in 1991. So you can clearly see that he held the position at a very, very critical point in time in the Middle East history. During his time at the helm, Israel reached a very historic interim peace accord with the Palestinians in 1993. I'm sure we're privy to the fact that Israel and Palestine, they have been at the forefront of a very long-standing dispute over borders, over the claim of over Holy Land. Both of these regions, they are making their respective claims over the Holy Land, which is very important, significant relevance for Christians, Jews, and Muslims. Their claims over Jerusalem. There's the issue of illegal migrants, though that is the conflict between both of these territories, and this conflict has been going on time and again. And there, during that time, a historic treaty was peace accord was arrived at with Jordan by Israel during his time. And this has brought us to the legal segment for today. And here, this is the first update. So the Supreme Court adjourns hearing of Bihar caste survey case until October. The Supreme Court, it adjourned the hearing in a batch of pleas doubting the constitutionality of the state-based survey conducted by the Bihar government last month. The division bench, it is hearing a plea by non-governmental organizations called Youth for Equality and Ek Soch Ek Prayas against the decision of the Patna High Court to uphold the Bihar government's caste-based survey. This verdict, it was declared or delivered by a division bench of the High Court. It rejected the contention that an attempt to collect data on the basis of caste, it amounted to a consensus and held the exercise to be perfectly valid, initiated with due competence. The bench directed the matter to be listed or relisted in light of a letter circulation which was circulated by the Standing Council of the State of Bihar requesting an adjournment. The name of this particular matter is Ek Soch Ek Prayas versus Union of India. Moving on to the next update, which also comes from the Honorable Apex Court. So the Supreme Court, it has refused to grant bail to Gurmeet Singh and to Subrata Bhattacharya, erstwhile directors of Pearls Agrotech Corporation Limited, a real estate company which is embroiled in a scam involving more than 40,000 crore that is said to have duped several investors across the country. A division bench of the Apex Court, it was considering applications for grant of bail in an FIR which was registered in 2014 in New Delhi. and in all subsequent complaints which were filed by different informants, investigated by agencies across the entire country. So, therefore, in light of this factual background, the Supreme Court added or opined that one cannot apply one bail order to all the other subsequent cases. We do not have the adequate particulars pertaining to the subsequent cases filed, like the charge sheet pertaining to the case, registered by different investigating agencies. It is not as if the applicants are unable to approach the concerned courts for seeking bail. So, therefore, the Supreme Court here held one cannot apply one bail order to all subsequent cases, and the name of this particular matter is PSCL versus the Central Bureau of Investigation. And this has brought us to an end of our TNA. In case you want to get access to the free study materials that we curate or the TNA slides that have been made use of in this video, I would invite all of you to please join our Telegram channel. There you can also find other updates, and the link of the channel is, you can scan the barcode or find the link in the description. The quiz, which is based on yesterday's TNA, it is also made available for your kind consideration. And I would highly encourage each one of you to please go ahead and attempt the quiz so that you're into the habit of practicing the questions daily. Thank you for being with us. And also, don't forget to put down your answers in the comment section. We would really like to hear from you. Thank you for being with us.